Okay, chapter 7. There's almost nothing in chapter 7 that you're going to expect to see on the test.
Except every other question.
Just a little bit. Just a little bit. A few things we might want to talk about in chapter 7. So obviously agency is a huge part of the test. And we want to make sure that you guys are comfortable with anything that you might see that comes from those sections. Give me the 4 perspectives of the firm. How can the firm participate in a transaction? Exclusive agency, so we could be exclusive seller, exclusive buyer, right? So the 2 exclusives. Dual agency. Designated is a form of dual. Remember, from the firm's perspective, dual is dual is dual.
Sub-agency.
Every situation you've given me so far only involves one firm. A cooperative sale. A cooperative sale. Don't forget that. That's the most common one, right? We can't forget the most common example of a transaction. From a firm's perspective, there's 4 different ways to operate in a transaction. Exclusive buyer agency, exclusive seller agency, some form of dual agency, or a co-brokered transaction where there are 2 firms cooperating with one another in the transaction. Is everybody okay with that? Now, from the buyer's perspective, what are the 4 choices? Exclusive buyer agency, designated dual agency, true dual agency, and the seller one what? Seller sub-agency. Seller sub-agency. Those are the 4 from the buyer's perspective, ranked from best to worst. What are the 4 from the seller's perspective?
So is designated dual agency, and then what was the third one?
You tell me. From whose perspective are we talking?
Buyer.
From the buyer's perspective. So you tell me, what way it's going to firm, represent, or deal with a buyer?
She just listed all of them.
She did, but I want you to, though.
I can't remember what it's called, but it's like the dual agency where they can't talk to each other.
The dual agency where they can't talk to each other. Designated dual agency.
Okay. Oh.
Is that what you're talking about?
And then there's just the regular dual agency.
Okay. And then what are the other 2? That's still only 2.
And then the seller sub-agency.
That's 3.
And the exclusive buyer.
There you go. 4 perspectives. Okay? What are the 4 perspectives from the listing side, from the seller side?
The seller sub-agency.
Exclusive listing, right? Which is the same thing as seller sub-agency. Okay?
Just remember it.
Okay, that's fine. That's fine. What else? Designated dual agency, true dual agency, and FSBO. FSBO, for sale by owner. Those are the 4 possibilities from the seller's perspective. Make sure you pay special attention to wording and those questions that deal with agency. Put them on teams. Draw your little chart with the buyer on one side and the seller on the other so that you're clearly dividing them up as you go through. That's going to be a huge part of it. If they tell you that, Salim is a broker affiliate of ABC Real Estate and he's been working with a buyer for the last 6 months, but ABC Real Estate doesn't practice any form of buyer agency. Well, what team do we put Salim on? The seller's team. Because if his firm doesn't practice any form of buyer agency, then he has to be on the seller's team. Does that make sense? So make sure you follow exactly what they're saying in those agency-based questions, because that's going to be a huge part of getting them right. Is just following what they're telling you is going on in the transaction. All right? So let's talk about the difference between implied agency and express agency. What's the difference between an implied agreement and an express agreement? Express, well, writing is express, but does it have to be in writing to be express? It could be an oral express. So what does express really mean then? Well, not implied. Yeah, that's true. So it just means we've clearly stated the terms of it. Express means we've expressed what our agreement looks like. Implied is by action. We haven't had a discussion at all about it. We haven't discussed it at all. We don't have that authority, but we've acted like we have that authority. And make sure that you don't ever do that. We never want to participate when we don't have the authority to do so. Okay? Is everybody good with that? Give me some examples of implied agency.
Thing with the property manager, or
What with a property manager?
when he decided to become a property manager, but only manage the property, not handle I forget what exactly he said.
He wasn't managing the property. He was doing what?
Oh, just selling.
He was selling it, but eventually they wanted to put a tenant in there. So he helped them find a tenant. But he's not managing the property.
Right.
But that still hasn't gotten me anywhere close to implied agency.
The tenant says something about needing maintenance, and the first number they have is the listing agent's number, so they call the listing agent and is like, oh, I need this done, and the listing agent's like, okay, well, I'll look into it.
Right there.
He's implied.
Right there. Because by saying I'll look into it, he's implied what? That he's the property manager. What he should have said.
He said,
Call the owner. Call somebody else. Call somebody who cares. Just don't call me. Right? Because I'm not the property manager. What are other examples of implied agency that would be really dangerous? Think of it from a buyer's perspective.
Or you can go and put in an offer for somebody.
Make an offer on behalf of somebody and not have what?
Authorization.
And what would be authorization? What do you need to put in an offer on behalf of a buyer?
I need an agreement.
A buyer agency agreement. So not having a buyer agency agreement and submitting an offer for that buyer anyway would be an example of implied agency, wouldn't it? Okay? And we don't ever want to do that. We don't ever want to get... I'm sorry? That is very illegal. Absolutely. Absolutely. It's very much illegal. No question. How do we terminate agency relationships? I mean, we know we create it with a buyer agency agreement, a listing agreement, a property management agreement. How do we terminate agency relationships?
one is designated.
Closing. So what else? They expire. What else? Both agree. So mutual agreement, right? Completing all the promises, so that'd be closing, right? Right? Can the client or the firm fire one another? No. This is a what? It's a contract, folks. You cannot fire someone from a contract. That is not how this works. This is not an employee-employer relationship. This is a contract. How do you terminate a contract? It was what Robin said. With what? Oh, I'm sorry. With what? Mutual agreement. That's a big difference between firing somebody. I can't walk up to a client I hate and say, you suck. I'm not selling your house anymore. I can't do that. Because guess what they have? A contract. And that contract works from both perspectives. I can't fire them and they can't fire me.
What are the repercussions, though, of you being like, I don't like you, I know we're in a contract, but I ain't gonna do crap for you?
They could sue me for failure to perform. Yeah. Yeah.
I feel like I just
Yeah.
don't do anything until they agree.
Because that contract outlines what we're supposed to be doing on their behalf. How about death of one of the parties? Would that terminate an agency agreement? Yeah. So what is death of? Obviously, if the seller dies, that's death of a party. How about on the other side of the contract? The firm would have to do what? Go out of business. So would it matter if the agent, the individual listing agent, died? No. Death of a buyer, death of a seller, death of any party to the contract. But what I'm saying is you need to understand what death of a firm actually looks like. It's not death of an agent. It's death of a firm.
Would that also be if the bank loses his authorization to operate as a bank at that time?
So that's death of a firm. The firm ceases to operate, that's death of the firm. All those agency agreements would go away. Okay? What is the difference between special agency and general agency? Where do we normally operate as real estate brokers? Special. We normally, as real estate brokers, operate in special agency. How much authority do we have? None.
What is the difference between special and general?
Gosh, that was going to be the next thing I asked. What's the difference between special agency and general agency? Well, if general agency has no authority, what's the next logical thing?
What do you mean special and special?
I mean, special agency has no authority. What's the next logical thing? General does not have all the authority. It has some authority. What's it called when you have unlimited authority? That's universal agency, which you would never be as a real estate broker.
We are special.
We are special agents most of the time because we have no decision-making authority. And if you think about that, if somebody makes an offer on a house, am I entrusted with accepting that offer? No. Who has to accept the offer? The seller, of course. Can I function as a general agent, as a real estate broker?
Yes. As a property manager.
Property managers. Why are property managers general agents instead of special agents? They can sign contracts. They have decision-making authority. Specifically, what contracts can they sign? Leases. Good. Yes.
Another question, just about the property owner. So it's correct that they have to, like, they would be a general agent if they were a broker, but you can be a property manager if
Who?
you're-
Back up. Who would be a general agent if they're a broker?
If they were a broker and a property manager, they would be a general agent.
Okay, so a property manager is a general agent.
Yes.
Yes.
But property managers, I believe you said they don't always have to be a broker if they're paid with a W-2 form, right?
Correct. You don't have that. You're exempt from licensure. That doesn't matter. That's still a form of general agency. Agency has nothing to do with licensure. Agency is anytime you're hired to stand in the place of somebody else. So a general agency relationship is anybody who's been given the authority to not only stand in someone's place, but to act on their behalf in certain limited settings. Okay, and a property manager has that right.
And is that just explaining the fiduciary responsibility to the principal?
That's exactly right. And how far my authority goes. This is just a line in the sand of how far I can go. If I'm a special agent, the line in the sand is much sooner than if I'm a general agent. And if I'm a universal agent, there is no line in the sand because I'm able to do anything on behalf of that person. Okay? So let's talk about exclusive agency for a second. When we have an exclusive agency relationship, we owe our clients loads, right? Those are all those duties. What are those duties? Loyalty. So what does loyalty mean?
You're only representing them.
I'm only representing them. What else do I do? What about their confidential information? I keep it confidential, so I don't ever disclose the confidential information of my exclusive client, correct? Never. What do I tell them that I know about the other side? If I'm in exclusive representation, what do I tell them I know about the other side? Everything if I'm in exclusive representation. Does that change when I go into dual agency? Yes. What would happen when I went into dual agency? I would not tell them anything. I would, because now I have representation of both sides. I can't tell either side what I know about the other. Good. So what else do I owe as far as loads go? Obedience. So follow their instructions as long as their instructions are what? Legal. I don't follow any illegal instructions. So give me some examples of illegal things that a seller might tell me to do or a buyer. Don't tell them about the hole in the roof, right? So failure to disclose material facts. Would I follow that command? No. What else? Think about offers.
If the buyer made an offer and you don't think it's a good offer, and they tell it for
Sean said disclose somebody else's offer. What if the seller said, hey, call Marilyn back and tell her that Jolie made an offer and it's better than hers? If the seller tells me to do that, am I going to do it? No. So it's obedience within the law. Okay? Good. Good. Sure, if the buyer agrees, but question is, why would they? I mean, I'd immediately be suspicious of anybody that says, well, yeah, that buyer said I could tell the other buyer what they were offering. Like, come again? I would hesitate to say I wouldn't believe you, but actually, no, I wouldn't hesitate to say I wouldn't believe you, because I just can't imagine why a buyer would ever do that. Do we owe them advice if we're an exclusive representative? And do we owe them accountability for their money? What are the ways we account for their money? Trust accounts. What else do we do to account for their money that we talked about on Friday?
We go through on the closing statement and we make sure and verify what we are capable of verifying, that is correct.
So all those entries on the closing statement that we can calculate, we're responsible for verifying. Does everybody agree with that if I'm an exclusive representative? Good. Good. Let's talk about misrepresentation and omission. So this deals with disclosure of material facts, right? What are the 4 categories of material facts?
What page is this on, do you know?
No. 145, 144, 145.
Impacts the person's ability to complete the transaction.
That's one category of material fact, the ability of my client to complete the transaction. What else? Facts about the property, right? Anything else? Something of special interest, and there's one other one. It kind of seems like facts about the property, about facts relating to the property. So things like zoning or covenants or those things. Do we have to disclose all those things?
Yeah.
To whom? Everybody. Does it matter what side of the transaction you're on, who you're talking to, whether you're a dual agent, exclusive agent? No. That is the point of a material fact. When we label something a material fact, we are saying that you must disclose it always to everybody involved with the transaction. So what are the 4 ways that we can screw up, for lack of a better term, when it comes to disclosing material facts? Willful misrepresentation, negligent misrepresentation, willful omission, and negligent omission. So let's talk about each one of those. First of all, what is a misrepresentation? When I say something that proves to be incorrect, right? When I say something that proves to be incorrect. If you're reading more into it than that, you're doing it wrong. Stop trying to decide. I cannot tell you how many times I get so frustrated with you all, because I'll ask you, is this a misrepresentation or an omission? And I hear somebody go, well, he knew, so it was a misrepresentation. What the hell has that got to do with anything? Nothing. A misrepresentation is what? When you say something that's wrong. It's a simple question, folks. Don't make it harder than it is. Did the broker say anything? And I guarantee you, they're not even trying to hide it in there. You just get so wrapped up in your own little brain. You hear that buzzing sound going off in there that you won't pay attention to the plain language that's in front of you. Travis responded. Well, if he responded, what did he do? He said something. So that means it's a what? It's a misrepresentation. If he didn't say anything at all, ever, what is it? An omission. Now we can deal with. And I know why you do it, because the word willful or negligent comes first, so you think you're supposed to do that part first. No. You have to decide first, is it a misrepresentation or is it an omission? Once you've made that decision, you say to yourself, okay, at that point in time, when he misrepresented, so at the moment, what moment are you looking for if it's a misrepresentation? If you're trying to decide it's willful or negligent, what moment in time are you looking for? The moment he what? Said something. You look at that one moment. Forget the rest of the thing. I don't care if they give you 14 paragraphs. Forget all of that. Because all you're looking at is that one little moment in time. At that moment, did he know that what he was saying was what? Wrong. If he knew for a fact that what he was saying was wrong, it is a what? Willful misrepresentation. If he didn't know that what he was saying was wrong, he was just guessing, that's a negligent misrepresentation. If it's an omission, and he knew he was supposed to say something and he chose not to, it is a willful omission. If he didn't know he was supposed to say anything, he didn't say anything and he didn't know he was supposed to say anything, it is a negligent omission. Okay? Is everybody good with those? Make sure you drill that down. Don't get caught up in the weeds on that.
Now, saying is equivalent to writing.
Writing, saying, emailing, texting, responding, answering, any of those words would all be misrepresentations. Putting it in a listing would be a misrepresentation. Over on page 147, we get into stigmatized properties. Are these material facts?
No.
They are not. They are not material facts. So, do we disclose them? Do we have to disclose them? No, we don't have to disclose them. So give me some examples of stigmatized properties that we don't have to disclose. Somebody was sick there. Somebody died there. What else? Haunted house, right? Convicted sex offenders. All of those are stigmatized issues, and they're not material facts. Material facts would be things like, the roof leaks. It's got bad plumbing. It's got, synthetic stucco would be something I would need to disclose. It's got polybutylene pipes. Those are all problems with the property itself that would need to be disclosed. Okay?
Nothing about the owner.
That's exactly right. Nothing about the people would be a material fact.
Unless they specifically ask, right?
Even then, it's not a material fact.
Well, isn't it if the buyer is like, I don't want to live in a house where somebody died?
Then it could become a material fact, but they will not test you on it that way.
Okay.
Yes.
How would you know if there's like sex offenders or something in your neighborhood?
You can check on the sex offender registry. The sex offender registry is public information, and there are several apps that integrate with it and show you like a real-time map with little balloon. Don't pull it up; you'll freak out. You know what I mean? It's one of those things you don't want to know, probably. There are lots of them. Okay. Let's see what else in here. What is designated dual agency?
One broker represents.
And you designate two individuals to act as outside firms so that they're co-brokering a deal. So they can act in their client's best interest.
They both work for the same firm. So to be designated dual agency, the first thing you're always looking for is one firm, right? Okay? And so who can be designated dual agents? Or rather, let me ask it this way. Who can't be a designated dual agent? A provisional broker and their BIC. Can provisional brokers be designated dual agents? Yes, but not a provisional broker who's opposite their BIC. They cannot be designated. So can the BIC be a designated dual agent? Yes, but as long as the person designated against them is non-provisional.
So did you say provisional broker can be a dual agent? But
Designated dual agent. Make sure you got designated, right? A provisional broker can be a designated dual agent. You just said dual. These rules apply to designated dual agency. So provisional brokers can be designated dual agents. They just cannot be against their broker in charge. So if the provisional broker is designated to represent the buyer, it could not be the BIC designated to represent the seller. Does that make sense for everybody? We good on that? Okay. Any other combination is okay. There is no other combination that doesn't work. Let's see here. Listing, I guess we talked about that in Chapter 8. Let me hold off on that. Okay. I think that is. Go for it, Ashley.
About the material facts.
Mm-hmm.
Facts relating directly to the ability of the agent's principal to complete the transaction, so we can disclose if there's a pending foreclosure.
Right. So anything that would impact their ability to close. Mm-hmm.
All right, anything that impacts.
Anything that impacts their ability to close. On page 162 and 163, I would, if I were you, to go and read those situations regarding dual agency and what kind of consent you need. 163. Basically, in general, you can always get oral permission for dual agency unless both parties already have what? A written agreement saying what? That they don't want dual agency. I mean, that's the long and short of this thing. You can always get oral. Now, first of all, you have to have permission for dual agency. Let's be clear on that. You always have to have the consent of both parties. And it always has to be in writing if you're going to do what? Make an offer. Make an offer. You've got to have written permission for dual agency to make an offer. But just to show the property, we can have oral permission for dual agency in almost any situation except what? When both have a written agreement already. So we got a written listing agreement and they say no dual agency. We got a written buyer agency agreement and they also said no dual agency. When you have that situation, what do you have to do before you can even show the property? Get the permission in writing to even show.
Now, what if one has it in writing they don't want it, and the other one doesn't? Can you just get oral?
You can still get oral in that case. Yeah. The only case where you can't is when they both have said no in writing. Okay? Is everybody good with that? Make sure you're good with that. Getting written permission or consent for dual agency. And you would always want to put it in writing no later than what? Time of offer. Okay? Now, if you go over to page 166 and 167, actually 170 is really where it picks up. We get into the Working with Real Estate Agents brochure. What's the purpose of the Working with Real Estate Agents brochure? Disclosure of what? What's my position? What's my relationship in the transaction? Who do I represent or who do I hope to represent, right? What is my relationship to you, whomever I'm talking to? And who is this you? Who's this person that I'm talking to? A what? A buyer or a seller, but not a... What transactions do we not use these in? We use them in commercial. We don't use it in what? Leases. I've said that at least 78 times already in this class. Do you think it's going to show up on an exam? Yes. Guaranteed. You use that document in sales transactions. Please pay attention to that. So whenever you're presenting this document, you're presenting it to potential buyers or potential sellers. What are you giving them? We said disclosure, but what else is it about? Information, but what else? Choices. You're giving them choices. Don't they get to choose how they interact with you? Ultimately, right? So you're explaining to them what their choices are. So why do we bother to get the thing signed? Proof of the conversation. Proof that we've offered them what? Choices. That's why we get the thing signed. Do they have to sign it? No, they do not. They do not. Can we still work with them if they don't sign it? Yes. Do we have to present it? At what point in time do we have to present it? First substantial contact, which means whenever they start giving personal confidential information. Preferably, we'd like to do it before they give personal confidential information, but certainly no later than the time they give us confidential information about themselves. So if they start to say things about themselves, what are you supposed to do? Stop. Right? You have the right to remain silent. Whether you do or not is up to you, but you have the right to.
On a regular, as a regular broker, how many of them actually do that?
Sean's question is a good one. How many of them do it correctly? Probably a lower number than we would like.
I've never seen any of them do it.
Yeah.
I don't think the one that the first real estate agent I had even showed me a pamphlet.
Yeah. Well, I mean, and it doesn't have to be in pamphlet form. It could be on, regular 8.5 by 11 paper, but you didn't get it. Yeah.
All I got was his exclusive.
Buyer agency agreement. Yeah.
One asked me a question. Are you seriously thinking about doing an offer? And when I said no, I guess
It didn't need to bother, right? I will tell you, one of the things the commission looks for when they audit people is what is the ratio of working with real estate agents brochures to transactions look like? Because the people who only have working with real estate agents brochures for the transactions they've closed, they immediately know you're not doing it right. Because think of how many people you're going to have first substantial contact with that you never do a transaction with. A ton, right? You probably have 4 or 5 times as many people with first substantial contact as you have actual transactions. So you should have a boatload. I'm telling you, I got a super fancy filing system for those things. A shoebox. I keep a shoebox in my office at the house, and if I go out and I show somebody property, I give them the working with real estate agents brochure, they sign the panel, I come back, I throw the thing in the shoebox. And somebody said, oh, well, if you have a transaction with them, what do? Go back and dig it out? I say, no, I'm too lazy to do that. I just make them sign another one. Simple enough. And if the real estate commission ever audits me and says, are you presenting the working with real estate agents brochure, you know what I'm going to do? Dump the shoebox on somebody's desk. There you go. There they are. Because the idea is just to prove that you're having the discussion with people. That's the point. Okay? So no later than first substantial contact. And make sure you know how to recognize first substantial contact. It's not first face-to-face contact. It is when that personal information gets exchanged.
So it's personal versus property. Talk about
Correct.
property.
Talk about property all you want to, but when you switch gears to people, you've got to stop the conversation at that point in time. Okay? Is everybody good with that? That is the working with real estate agents brochure. What kind of transactions? Sales, not leases. Sales, not leases. Over on page 174, it talks about oral buyer agency. Now remember, listing agreements always have to be what? Written, in writing. From the very outset, from the very beginning, your listing agreements have to be in writing. That's not true of a buyer agency agreement. Can we have oral buyer agency? Yes. Give me some up to a certain point. I heard Ariana already chiming in. Good. Up to a certain point. What point is that? Until we want to present an offer. At the point in time we're going to present an offer on behalf of that buyer, we have to put this buyer agency agreement into writing. Now, what are some of the key ways to recognize that it's an oral buyer agency agreement? What things can we not do with an oral agreement that we can do with a written agreement? It's non-exclusive. So an oral agreement cannot be exclusive. It means we can't bind the client to us and they can't bind us to them with an oral agreement. What else? They can fire you because they can work with, they didn't hire you. That's exactly right. They can work with multiple firms. They can they go out and look at property today with Rachel and tomorrow with Ashley and tomorrow with, Sean and Sunday with me? Sure. Absolutely. So all those things are stuff to recognize with oral buyer agency. Good.
Do a lot of real estate agents even do this? Because why would you want to do this?
Gosh, a shocking number do this. I'll tell you why. You ask the question, I'll give you the answer. The answer to why real estate agents do this is they don't want to have a conversation. They don't want to have to explain to the buyer why the buyer, because buyers are going to be reluctant to sign these things. Think about yourself. Somebody puts they're 5-6 pages long. Somebody puts 5 pages of legal language in front of you and says, sign this. What is your natural reaction? What is it? I don't want to do this. I don't want to. It really boils down to that. People are not comfortable having the conversation. Now, I'll tell you what my approach has always been. And I tell everybody, Your mileage may vary. You got to do what feels comfortable for you. My approach has been for years, I will go out with anybody one time with an oral agreement. I'll show houses. We'll spend the day. I'm fine with that because you need to know how I work. You need to know if you're comfortable with me. I need to know if I'm comfortable with you as a buyer, all those things. But when you call me back the next weekend and you want to go out again, guess what I'm bringing with me on that trip? Buyer agency agreement. Because at that point, if you like me enough to spend 2 whole days and you calling me back, we need to do a permanent engagement here. That's just my philosophy on it. If you do oral buyer agency, you certainly open yourself up to being taken advantage of. That's the downside, because they don't have any obligation to use you once they actually make an offer.
So when they find a house, they can just get their home for it themselves.
They could. Absolutely. I mean, I've seen it happen where people were looking for houses and their brother was in this class, and they're out looking with another agent and they find a house that they want to make an offer on, and they wait till the following week when their brother passes the license exam and let him write the offer up for them when this other agent's shown them the house 4 times. I've had people in this class come and tell me that their family was doing that.
That's not legal, though.
It is very legal because oral buyer agency is non-exclusive.
Yeah, that's what I was gonna say.
Yeah, you can't tie them down in any way. Okay, can't limit them on time. There's no limits whatsoever to it. Okay. Got to put it in writing before we make what? An offer. Good. That's it for chapter 7. All right, chapter 8, agency contracts. Agency contracts. Obviously, the most common example of an agency contract is going to be the listing agreement. The listing agreement is the basis for our business, really. So what's special about listing agreements? They always have to be what? In writing from the very beginning. Good. What are the different types of listing agreements that we talk about in this chapter?
There's
Open listings, exclusive agency listings, and the exclusive right to sell. Which one is by far the most common? Exclusive right to sell. Under what conditions is a listing firm owed a commission with an exclusive right to sell listing? Any circumstances. Under what circumstances is a listing firm owed a commission with an exclusive agency listing?
All except for if the homeowner sells
All except for the owner, seller
it.
sells it themselves. So if the seller produces the buyer, they don't owe a commission. Under what conditions is the listing firm owed a commission with an open listing?
only if they present the buyer.
Only if that listing firm produces the buyer. Good. So over on page 188 and 189, we've got some solicitation laws. The first that we need to talk about is the Do Not Call Registry, the National Do Not Call Registry. So this is a list of phone numbers that you're not supposed to call unless you have their permission to call them. How can you get their permission? Or more, so what are some ways you can get their permission to call? Let's start there. They give you contact information, right? They put it on my website, call me. That's one way. What's another way? They were my client. Both of those represent permission to call them. Are they good? Is that permission good for the same amount of time in both cases? No. How long is that permission good for if they go on my website and say, please call me? 3 months. 90 days. How long is that permission good for if they were actually my client? 18 months. 18 months. We have 3 months if they ask us for information to contact them. We have 18 months after we actually work with them in a transaction to continue. Yes, Caitlin.
Would they ever ask a question specifically saying 18 months after your last substantial contact with them, meaning like if you call 6 months later and say, hey, how's it going, is it okay if I call you in another 6 months and it continues to read up? They ask you a question.
No, I can't imagine how they would necessarily phrase that, so I don't think so. Now, I mean, it's a good question, but I don't really see how they could ask that question and be clear about what they were asking. So I think it's going to be pretty abundantly clear that they're referring to either somebody you did a transaction with or somebody that just basically called and said, hey, give me a call back. Okay? Is everybody good on that? The other laws that govern solicitation, the CAN-SPAM Act deals with what kind of email. And what do we have to do to be in compliance with that? They got to opt out, an unsubscribe link, right, on the email. Good. And you don't need to worry about the junk fax laws. Bottom of page 189 into page 190, you do need to know about antitrust, the federal antitrust laws, okay, specifically the Sherman antitrust laws and price fixing. And we need to know about both price fixing and we need to know about what? Group boycotting. That's exactly right. Price fixing and group boycotting. So what is price fixing? Give me an example of price fixing.
My firm, other firms do 8%. Me, I do 6%.
That would be an example of price fixing. That's a perfect example. Well, everybody else is going to charge you 8, but I'm going to do it for you for 6, my friend. That would be a perfect example of violating the Sherman Antitrust Act. What could we say in that situation?
My firm usually does this.
My firm charges this. Yeah. Well, you can say, but I'll reduce it to this. You could do that. As long as you make it clear it's what your firm is doing or what you personally are doing, you're fine. Good. When are commissions negotiable? Always. In all cases. Can you avoid showing a firm's listings because maybe they don't pay a good buyer side commission? Can I avoid, I'm not going to show Ariana's listings because she only pays 1% to buyer's agents? No. No, I cannot. I absolutely cannot. People will say, well, that's not fair. I'm only going to make 1%. That's not true. That's why we have a buyer agency agreement, because the buyer agency agreement guarantees what? Whatever percent I put on there. So that's why I have a buyer agency agreement, because the buyer agency agreement says this is what you, Mr. Buyer, will pay me if the seller does not. Does that make sense?
So basically, if you're charging like 6% and the seller's only doing 1% and the buyer has to do the rest of
Pay the difference. That's exactly right.
the buyer
And so that's a reason you would want to have a buyer agency agreement, so you don't have to worry about what it is that Ariana's offering as commission, because you know what you're going to get paid no matter what. The question is whether it's being paid by the seller or whether it's being paid by your buyer. Does that make sense for everybody? But you do not avoid showing people's listings because of what they pay. Yes?
I'm trying to make sure that, it makes sense to me, but what if you don't know, what if I'm representing the seller, for example, and we agree to 6% commission? Well, what if I don't know that the buyers only agree to 3% or something?
What difference does it make to you if you're on the seller side?
I don't know, maybe I didn't understand what you're saying.
Yeah, you're on the seller side. It doesn't make any difference to you what's going on the buyer side, right? Because your listing agreement's going to say, I'm charging 6%, and then it's also going to say how much of that 6% you're sharing with a cooperating firm. So how much are you going to share with a cooperating firm? I'm asking. There's no right answer. Just what if you it's your hypothetical. So if you charge 6%, how much would you share? 3%. Okay. So you know you're getting paid 3% no matter what, and you know the other 3% is going where? To the other firm representing the buyer, right? So the only thing that would matter would be on their side, because what they would have is a buyer agency agreement that details how much they're going to get paid in the transaction. And if that number was 3% or less, then the buyer's not going to owe them any commission, because the commission coming from your side is enough to cover it. But if they had 3.5% on their buyer agency agreement, guess where that other 0.5% is going to come from?
That's the part I don't understand.
Where would it come from? Who's the buyer agency agreement with?
Mine is with the, or theirs.
It's your hypothetical, Michaela. I'm working with yours. You said you were the listing agent, right? and you listed a property and you charge a 6% commission. Okay? And I ask you how much of that commission you're going to share. 3%. So Ariana brings you a buyer. How much of the commission are you going to give to Ariana? 3%. She has a buyer agency agreement that says she's going to get paid 3.5%. Does that impact you on the listing side at all? What do you think? No. Because who's her buyer agency agreement with? Her client, the buyer. So who's going to owe her the difference between what you paid and what she said she would work for? The buyer owes her the difference. That's exactly right. It doesn't impact you at all.
So she would get paid the extra 5%.
That's exactly right. Because she has a buyer agency agreement where her client agreed that's what she would be paid. Does that make sense? Okay. How about if you've got an inspector that nobody likes? Can you get together and decide not to use that person? What's that called? That's called group boycotting. Good. Good. I'm sorry? 190.
Fourth paragraph.
Okay, I see it, yeah.
All right. We talked about the different types of listing agreements. Give me some things that should show up in a listing agreement. What kinds of things should be in a listing agreement? An expiration date, because we got to have that. What else? The duties. What do I have to do? What am I expected to do? There's a phrase I was looking for. It should outline when I've earned my commission. And in most listing agreements, like the exclusive right to sell listing agreement, what is the phrase that we use that determines when we've earned our commission?
Ready, willing, and able.
A ready, willing, and able buyer. That's when we've earned the commission, when we produce a ready, willing, and able buyer. Good.
Where does that go? Does that go in the term of agreement?
I'm sorry?
Like, within the agreement, where is that?
Where
Where would that be located in some?
there's a paragraph that says firm's entitlement to compensation or firm's compensation,
Under B.
7B.
So you can still sue for your compensation if, like, let's say the person that lives in that house said, I want to keep my house, but you guys get all the way to closing, and she just like, you know what, keep it.
I'm not selling.
Yeah.
Absolutely. And it doesn't even have to go that far. How about if I bring them a full price cash offer and they just refuse to sign the offer? Have I produced a ready, willing, and able buyer? Absolutely. And I could sue for my commission. So I've earned it when I produce a ready, willing, and able buyer. I may not get it then, but that's when I've earned it. Okay? Everybody good on that? Okay. We talked about the different types of listing agreements. We talked about splitting fees. Let's talk about square footage, living area, determining living area. First of all, is square footage or living area a material fact in North Carolina? No. It is not. Living area is not a material fact. However, if you choose to use it, do you have to be accurate with it?
Yes.
Page 227. Yes, you do. And are you going to choose to use it?
Yes.
Yes, because most likely you're going to be listing the property where? On the MLS. And what's one of the rules for listing a property in the MLS? You got to put square footage. So even though it's not a material fact from the Real Estate Commission, the likelihood is that you're going to be disclosing it. And if you disclose it, you've got to be accurate with it. So, who measures the property? Or listing broker or an appraiser. Those are the only two choices. Can you use old tax records? Can you use old listings? No. What are the rules for measuring? Where do you measure? Outside. You take exterior measurements whenever possible. And when it's not possible to measure outside and you have to measure inside, what do you do to account for that? Add 6 inches for the exterior walls. Not subtract. If you think about that, it doesn't even make sense. If I measure from wall to wall, I'm not going to subtract, right? Because then I'm in the middle of the floor. If I was measuring outside, it would be longer, right? So I need to add 6 inches.
Is that, so would it be technically 24 inches that you would add if the house is square?
You add 6 inches in each direction. So 6 inches that way, 6 inches that way would be a foot. 6 inches that way, 6 inches that way would be a foot, assuming you couldn't measure anywhere exteriorly. So if you had to do all interior measurements, then you'd add 6 inches to each dimension.
Yeah, I was about to say you be living underground.
Sorry? It's fairly close. Relatively close.
Is that 6 inches, like, if, let's say we were measuring this room and the 2 bathrooms, so we measure this room plus 6 inches, 6 inches, and then.
For any exterior walls. 6 inches for any exterior walls.
Oh, so that makes sense. Okay.
Yep.
If you had a townhome and it's one big long row,
Mm-hmm.
you can't technically.
You can't really tell where it stops and starts, right?
Well, can you just do the end and then the end and then the front of the house and the front of the house kind of thing?
Yeah. So
Or is it technically the same thing, so you don't have to look inside?
that's right. That's exactly right. You measure the end unit a lot of times, you know. Yeah. A lot of times if you have them where there's just one big building and yours is the middle unit, I'll measure the exterior of the end unit, you know, because you can measure the width, because you can tell where it stops and starts width-wise, but back to front, you can't really measure your house, you know. So what I'll do is go measure the end unit, because they're all the same size. So
Townhome is, I've never seen a townhome that's not identical.
some of them are. There are some ones that'll have, like, you know, mixed styles. They'll have like a 1-story on the ends and 2 stories in the middle, but most of the time you're right. They're identical all the way down. Okay? Condos, you would always just measure inside, because condos don't include the exterior walls. Okay? What are the other rules for square footage? Must be connected to other living area. What's the number 1 rule? Heated, permanent heat source. What else?
7 foot.
7 foot minimum ceiling height, and directly accessible from what? Other living area. How about stairs? Stairs count as living area? On which floor? Both. Good. Good. They talk about pricing the property at the end of Chapter 8 or doing a CMA. Who do we do a CMA for? Buyers or sellers or both?
CMA is for clients.
It's buyers or sellers or both?
Oh, yeah.
Yeah, both. Okay. I love how I give 3 choices and yeah. See how that works on the exam for you.
I'll just write
Yeah.
yes.
Yes, just write yes there. It will not come out well, I promise. Page 228, the North Carolina Residential Property Disclosure Act. The Residential Property Disclosure Act. First of all, what are our requirements with the Residential Property Disclosure Act? What do we do as brokers? Really? We don't do anything?
Oh, we have to give it. We have to make.
Give who the form? Give the form to seller and tell them to do what? Fill it out. Good. That's not nothing. That's something, right? What do we not do? Fill it out. Answer the questions. Does it change our responsibilities in the transaction at all? No, it has no impact on us. None whatsoever. Okay? Does the seller have to disclose anything they know about their property? No, they don't. What can they check? No representation. Good. Good. And if the buyer doesn't get it before they make an offer, what kind of time period do they get? 3 days to terminate any contract. Everybody good with that? And the mineral oil and gas disclosure, same rules. Same exact rules.
Why is square footage not a material fact?
Why is it not a material fact? I don't know. That's a good question. She asked why square footage was not a material fact. And I don't know the answer to that. I just know it's not. You're not required to do it. But you are required to be accurate about it if you do it. And the simple truth is, if you list it in the MLS, you have to do it. So you got to be accurate with it. You got to be accurate with it. All right. Is everybody good on that? I think that's it for Chapter 8, except the math of doing commission splitting, which we'll go over when we do the math packet. Make sure you're good with splitting up commissions. All right, let's do Chapter 9, and then that'll wrap it for today, I think. Chapter 9. Contract law. What is a contract?
Binding agreement that can be held up.
Legally binding or enforceable agreement between what? Two competent parties, right, with a set of promises. What are some necessary things for us to have a contract? Two competent parties. So what does it mean to be competent? They have to be what? Of age, not intoxicated, not crazy with paper, so not mentally incompetent, right? What else? How about duress or undue influence? Can they be under either duress or undue influence? Duress is the threat of what kind of harm? Physical harm. Undue influence is emotional harm. Duress is the threat of physical harm. If you don't sign this, I'm going to stab you.
Don't they have to be like legal? Like basically what you're agreeing upon.
Has to be for a legal act, absolutely. And we have to have consideration. What is consideration?
Money.
Money, some promise of the exchange of value. Do we have to have an earnest money deposit? No. Do contracts have to be recorded? No. Do they have to be in writing? Not all, but do real estate sales contracts have to be in writing? According to what law? Statute of Frauds. The statute of frauds says that real estate sales contracts must be in writing. So has to be recorded. In writing is understood because you can't record it unless it's in writing. The contract is that certain documents have to be recorded in order to be enforceable. And so what that means, if it has to be in writing in order to be enforceable, if it's not in writing and it's on that list, what kind of contract is it? Unenforceable. That's exactly right. So a real estate sales contract is covered by the statute of fraud. So therefore it has to be in writing to be what? Enforceable. So if I've got a real estate sales contract that's not in writing, what kind of contract do I have? I have an unenforceable one. Okay? See how that works? So let's talk about valid, void, voidable, and unenforceable. A valid contract is binding on which party? Both of them. Both parties. A voidable contract is enforceable on which party or how many parties? One party. Only one. Well, it doesn't have to be just in the case of, if it was a case of like an intoxicated person, it would be the sober one who was bound. But that's not the only reason we can get to voidable. Give me some reasons that we get to voidable. That is not how we get to voidable.
You don't fulfill a promise in the contract.
What do we call that when I don't fulfill a promise? A breach. So if we have a valid agreement and I breach it, we'd go from valid to voidable. What else gives us a voidable contract? Think about contracts where only one party is bound. I'm sorry? One's with a minor. A contract with a minor would be a voidable contract. Because who's bound? The adult. The adult is bound. How about contract with an intoxicated person? Is that voidable? How about a contract with somebody under duress? Is that voidable? How about a contract with somebody under undue influence? Is that voidable? How about a previously valid contract that was breached by one of the parties? Yes, all those are examples of voidable contracts because they're only binding on one party. It's not that there's for an illegal act. What do we call a contract that's for an illegal act? We call it a void contract. A void contract is one that's for an illegal act. It never was binding on anybody because it can't possibly be. That's a void contract. That's very different than voidable. Here's how different they are. Voidable is when a buyer is suing a seller and saying, Your Honor, they promised to sell me the house. Please make them do it. That's voidable. Void is when a crack dealer is suing a user and saying, Your Honor, they agreed to pay me $150 for that hit they just took, and they smoked it and they didn't pay me for it. Do you know how insane that sounds? Right?
So is void only for illegal sales?
Yes, ma'am.
So what if there's a breach of contract by both parties? It's still
Then,
voidable?
no.
Unenforceable.
What is it when it's not enforceable on either party? Unenforceable. So what's a void contract? An illegal act. You don't need to equate that with anything. A void contract is off there by itself out in the nether regions. You don't go to court with a void contract because you probably end up in jail. Because what you're contracting to do was illegal in the first place. But with unenforceable, valid, voidable, anything else other than void, you may end up in court over it. Does that make sense? Everybody good there? Okay. So make sure that you know specifically the voidable ones. They really like to ask about voidable. Do you know what makes a contract voidable? Okay. So make sure you're familiar with those. Good. Offers. Page 262, 263. What's the number one way to reject an offer? To make a counteroffer. A counteroffer rejects any previous offer. It's the most common way to reject an offer. How long does an offer stay valid? Until, well, if we put an expiration date on it, that's one thing. But generally speaking, until we do what? Until we revoke it or it is accepted. Offers generally live forever until it's either revoked or accepted. Okay? Everybody okay with that?
Oh, I got a quick question.
Go ahead.
I don't know if this would be on the test, but can a contract be voidable if it doesn't have consideration in it?
Can a contract be voidable if it doesn't have consideration? A contract that doesn't have consideration is an unenforceable contract because it doesn't meet the requirements, because in order for a contract to be enforceable, there has to be consideration. Yep.
But it doesn't have to necessarily be money, correct?
Something of value.
Anything of value.
Something of value. The promise of exchange of something of value. Okay. Over on page 264, they define the phrase, time is of the essence. What does that mean?
Must be done by state or
Definite date.
Specified time. Drop dead date, right? Got to be done by that date. So anything that says time is of the essence in a contract, make sure you do it exactly by that date. Let's see. Over on page 266, we talk about breaches of a contract and the remedies or fixes for a breach. First of all, do all of the contracts that we use in this class, that we teach you in class, have specific remedies for breaches? Do they say what will happen in the event of a breach pretty much? Yeah, the sales contract does, the listing agreement does, the buyer agency agreement does, pretty much everything we do. Now, when we talk about remedies or damages, there are three main categories: compensatory damages, consequential damages, and what's the last one? Liquidated damages. What type do we deal with most often in residential sales? Liquidated damages. What's special about liquidated damages? Pre-negotiated, agreed to by both parties, so we don't go where? To court. Good. What are compensatory damages?
Money you could prove.
Money I can prove, an actual loss, right? Something I can show you receipt and say, you cost me this much money. What are consequential damages?
Can't put money in it.
Can't put a price tag on it. Pain and suffering, right? He hurt me so badly. Let's see, on page 267, they talk about the broker's authority to prepare documents. What can we do?
Fill in the blanks.
Fill in the blanks on pre-printed forms. We don't ever draft contract language. If you need to do that, where do you send them? An attorney. What does the word addendum mean?
Change.
An addendum's not a change. An addition. An addition. What is an amendment?
That's a change.
That's a change. An addendum adds terms to a contract. An amendment changes the terms of an existing contract. And that's it for chapter 9. Look at that.